This is Elizabeth Townsend Guard, and this is Just Wanna Quilt. It's a research podcast coming out of Tulane University Law School, and I am a law professor. My focus is intellectual property, and especially copyrights and trademarks. Today we're going to be reading Chapter 3. We've been reading the book I wrote, Just Want to Create Copyright and Fair Use Strategies, and today we're going to read Chapter 3, which is called Basics of Intellectual Property. If you're interested in purchasing the book, which is not a requirement, of course, just go to our website, which is Just Wanna Quilt, and you can find information about that. There, I also have put the link to a digital copy in the notes for this chapter. For this podcast. Anyway, okay, here we go. Chapter 3 of Just Want to Create Copyright and Fair Use Strategies by Elizabeth Townsend Guard, and we are reading Basics of Intellectual Property. All right, here we go. Chapter 3, Basics of Intellectual Property. Identifying the differences between patent, trademark, trade secrets, right of publicity, and copyright. For artists, musicians, filmmakers, quilters, and other creators, copyright law is important and is often ignored until it has already become a problem. The core of what we do as creators is regulated by copyright. Copyright law fits into a larger group of laws called intellectual property. Intellectual property is the legal system that protects our inventions, creative works, our business secrets, and even the economic rights of famous people, and regular people too. Intellectual property includes 5 topics: copyright, patent, trademarks, trade secrets, and right of publicity. Intellectual property rewards creativity and innovation. It also protects business elements. Each area has different requirements, rules, and exceptions. Intellectual property is like any other property. Land, a table, your dog. It can be purchased and sold. A painting, a quilt, a book of music, are all physical, tangible property. But what makes intellectual property intellectual is a second set of rights for intangible elements. Your house is tangible. An apple is tangible. A song, the song itself, is not. We call it public goods problem. There is no natural way to keep you from singing my song, telling my version of a story, or copying that really cool art quilt you saw at a museum. And so copyright law comes into play. The government gives to the author a limited monopoly to exclude others from singing that song for a certain period of time. The same is true for inventions and other intellectual property topics. The creator or the controller of the intellectual property is granted a limited monopoly by government. So let's talk about that one more time. That means that, like, if you had a house, you could defend your house, right? You could put a fence around it. You could have a gun. You could do all kinds of things to protect. You can lock your door. But if I sing a song to you, there's nothing that inherently keeps you from also singing that song and trying to make money off of that song. And that's why we need the government to come in to put in rules and regulations about when you can sing that song and that I made, and when, and that's all the copyright law stuff. And that's why all the NFT stuff is so interesting, because we had a recent court case come down about Birkin bags, just a couple days ago. Can somebody else make NFTs of Birkin bags? And the court said no. That's not their, there's a property right that extends to the space of NFT creation, and that's, even though it's an intangible thing, something that's digital, in some way intangible, it's not up to, it's the Birkin company, the people who make Birkin bags get to decide who makes NFTs, not just some random person. Okay. Laws help exclude others from using your invention, creation, or logo. But right behind those exclusive rights, there also exists exceptions that allows others to use your work without permission. This is the bargain of copyright law. You get a bunch of rights to the work you create, but so do others, almost immediately. Another distinction is that the song is coming from you, and so many see the right the right connected to that song is personal, special, and deserving attribution that is different from the company that built the house or assembled your toaster. That somehow intellectual property is has kind of like your spirit or who you are, and that somehow that needs to be protected more than, again, say, the apple that you buy at the store. Okay, we'll talk more about that shortly. Types of intellectual property. There are 5 basic types of intellectual property, and a thing can fall under more than one type. Let's take a look at them. Patents. Patents protect inventions, like elements in the sewing machine, medical devices, and some interesting chemical acts. Officially, it is a grant by the federal government that gives the inventor the exclusive right to exclude others from making the patented object for a specific period of time. In this case, it's 10 years, like you have to go through a huge process, but it's 10 years from the date of filing if your patent goes through. Then it comes into the public domain, and we can all make our own version of that invention. The trade-off is that you have to disclose the invention at the time of filing, so when it comes into the public domain, everyone can use the invention. There are a number of different types of patents: design, utility, and process, design, utility, and process patents. And patents generally last for about 20 years. You must apply for a patent with the United States Patent and Trademark Office. They are not easy to obtain and can be expensive. Examples of patents in the quilting world include block lock rulers, the thread cutters, CUTTERZ, which both has both a utility and a design patent, and a whole host of June Taylor products. Jill Rep of June Taylor has been on the Just Wanna Quilt podcast a number of times. She talked about the importance of patents and how some inventions are big hits, while others, no matter how inventive, never quite work. Her thoughts on the inventive entrepreneur are refreshing, honest, and fun, and often a relevant perspective to inventors outside of the quilting world. So for those listening, go back and check and look for Jill Rep. She's just brilliant and amazing. We've got a number of interviews with her. Why do people spend time and money on patents? It gives them the right to exclude others from manufacturing the patented work and gives them advantages in the business world. If you have a process, invention, or something that is functional, you can investigate whether the work might qualify for patents. We do have a book out called Just Want a Patent: The First Steps by Ricardo Gonzalez, and that is available if you go to Just Want a Quilt. You can get more information on that. Trade secrets. Anything that is economically valuable to a business that is kept secret and not disclosed to the public or others can be a trade secret. Customer lists, business strategies, and recipes are examples. They are protected by both federal and state law as long as the secret remains secret. You have to take reasonable measures to keep it secret. I was recently at Wizard WorldCom in New Orleans. This is in 2020, and I saw a booth where an artist had created old-timey sheet music and then overlaid them with images. The musical composition was his interpretation of the theme song from the show or character depicted in the image. When I asked him how he made them, he responded, "Trade secret." I said, "Really?" I followed up, and he said, "Yes, really. No one can know how I make it. It's my competitive advantage." Trademarks. Trademark law is for the purpose of protecting your brand and to help identify your company and your products. Logos, business names, and product names, packaging all fall under trademark. Block lock may have a patent on a little groove that keeps a 1/4-inch seam from moving when cutting, but its trademark name, Block Lock, tells us what it is. The idea is to inform and keep you, the customer, from being confused as to the source of the product, and to cut down on your time in looking for a particular product or good, which is a good or service. If you can quickly identify Block Lock, that cuts down on the search cost in your purchase. The idea of a search cost is a term that we often see in trademark. The same is true on fabric lines. You can tell the shop that you're looking for Island Turtle Hand Batik the latest Kaffe Fassett Collective, or a Michael Miller print. That's trademark in action. Trademark can be a powerful tool. Cook companies use trademark in many ways. You buy particular tools because you trust Havells, Olfa, or Quilter Select. You have a particular sewing machine company and you buy a Juki rather than a Brother or Genovi, or you're a Bernina person. That's trademark at work. You only buy Tula Pink fabric. Your long arm is made by Grace Quilting Company. These are all trademarks that help you and others identify a product or service. The trademark stands as their goodwill. Goodwill is a term. When you think of a goodwill of what you think of when you see their mark. You buy some more products from companies with a trademark that you know and trust. And artists in other fields may only use paints, paper, pens, brushes, or software from specific companies as they have loyalty to that trademark. We found, however, that many companies, especially new companies, are not filing for trademark. This leaves them vulnerable in many ways. We have just finished. We wrote Just Won a Trademark, but Sid Gard and I have literally just finished, turned in the manuscript to C&T Publishing for Just Won a Trademark for Makers, which is an extended, really great. We're so excited about this book, but it's a book to help with this problem. It is available for pre-order at Amazon as we speak. Can you imagine? It comes out in September of 2023, but you can go there and order it now. What that book does is it takes you step by step through the process of how you apply for a trademark at the Trademark Office, and then does a little bit more as well, sort of what you do once you get one. But it's very thorough, and it's really, really thrilling to be at this place with that book. But we did an earlier version of Just Won a Trademark that was self-published that may or may not be available. I think we've pulled it from most places at this point in anticipation of the next one. But that one is also something that we had been working on. So for the last few years, we've been encouraging and teaching people on how to register their trademarks, either on their own or with an attorney. We've seen the Quilt District, Quilted Twins, What's Your Stitch, Social Justice Sewing Academy, and many, many more register their trademark. If you use your trademark as a hashtag, you're vulnerable that something else might also start using it as a source identifier, and you won't have as much recourse if you haven't registered it with the USPTO. That's what Just Won a Trademark for Makers, the book that will be coming out in September, is all about. Right of publicity. It's the law that protects the economic value of one's name and likeness from being used without permission. If you're famous, there is an economic right in your likeness, image, voice, name, etc. Think the Kardashians. And if you're a regular person, you're often asked to sign waivers to have schools post pictures of your kids on their school website or events at work. In this instance, in the instance of your kid, you're waiving the child's right of publicity and or privacy. We've talked to a number of celebrities in the quilting world, including Alex Anderson, Mary Fonz, and Marianne Fonz, all who discussed in their interviews, which you can get on this podcast, the value and issues that arose around the right of publicity in legal contracts. So when Mary Fonz brought Tula Pink to the house, to our house, which a very exciting moment to have both Tula Pink and Mary Fonz in the house upstairs in the quilting studio. They came to be interviewed for Just Won a Quilt. The power of the right of publicity was palpable. The house has never been cooler, not in the 100-plus year history of our house. And it's still the interview that is most listened to and most commented upon when people talk about the show. So for both, wherever they go in the quilting world, people line up to see them. They get autographs, they take pictures with them. There is a value in being around them. That's part of their economic power, and that is protected by the right of publicity. You can listen to our interviews with Marianne Fonz, Alex Anderson, Tula Pink, and Mary, which was in our first season, is when we did all of those. Copyright. Copyright protects creative works. We'll learn a lot more about that soon. For now, we have to understand that copyright protects all kinds of creative works, software, photographs, sculpture, movies, sound recording, everything. We'll talk more about that in depth. But that is the fifth one is copyright, and we will be talking more about it.